type of areas does everyone practice? Anybody do matrimonial? You do. No. Real estate? There you go. Criminal? All right. So before we start, if you guys have any questions during the presentation, just interrupt me, please. The topic for tonight is going to be military retirement benefits and how to distribute those during a divorce in a way to best benefit your client. Come on in. And of course, here's the Tully Rinckey spiel. We do everything, we have offices everywhere. I guess that's the bottom line. All right. There's several different types of retirement benefits. Your first is going to be your basic retirement pay. That's what we think of when someone has a state pension. There's also military disability retirement pay. That is if you are disabled sufficiently that you cannot perform your military duties and you have a sufficient length of time into the service. There's also concurrent receipt disability pay, which basically means you can receive disability benefits and retirement pay at the same time if you qualify for that program. There's also combat-related special compensation, which is basically just an extra payment if you have combat-related injuries. And the one that's going to create the most litigation is going to be VA compensation. And that's basically just a disability benefit based on your disability rating. And we'll get into those a little bit longer. The military has an all-or-nothing system. So if you don't meet these requirements, you get nothing. And for the Army and the Air Force, you have to be in for 20 years accredited service. For the Navy and Marine Corps, 30 years. For the Reserves and the National Guards, you have to have 20 years in which you receive 50 points or more. And the way you get points is by doing your monthly drills, by going on active duty, or by performing at a funeral. There's other ways as well. So let's start with retired pay. It's based on how long you've served, your rank at the time you retire, your final pay rate, and any cost of living adjustments. And cost of living adjustments can be very valuable because if you go into the service at 18, you retire at 38, probably still got a good 40, 50 years before you kick the can. So that can probably double your retired pay. Okay, and let's go back about 30 years, and there wasn't much of an issue dividing, retirement pay and divorce. It's much like if anyone has any matrimonial experience, you divide any pension. The spouse is entitled to half of what accrued during marriage. But back in 1979, there was a Supreme Court case, U.S. Supreme Court, of McCarty, which said that the states did not have the authority to divide a military retirement. So basically, the spouses got screwed. So in response, Congress passed the Uniformed Services Former Spouse Protection Act, which said that these retirement benefits could be divided if state law provided for that. Oh, I would love it. Thank you. Thank you so much. Okay, so that was passed directly in response to McCarty v. McCarty. The site, if you're interested, is 453 U.S. 210, and that was in 1981. Like I said, the retirement benefits are based on the rank at the time of retirement, not divorce. So if you are a captain when you divorce, but you are a general when you retire, your spouse is going to get the benefits based on the general status, which is going to be a lot more. And the former spouse can receive up to 50% of the member's disposable retired pay, or 65% if there's a child support order involved. Okay, so there's some options for dividing retired pay. Now, if the service member is not retired, to do a fraction. If anyone's familiar with any New York matrimonial law, that would be what we call majuscus. So the former spouse gets half of what accrued during the marriage. So, and that fraction would be, the numerator is going to be the months of service during the marriage, and the denominator would be the total months of service. So the spouse would get half of that. Or really, in New York, it could be any percentage, since we don't really have to divide it exactly in half, since we are equitable distribution and not community property. But I digress. Or if the service member is retired, you know how much they're getting. So you can just say, all right, you're getting $3 grand a month in retirement. We were married for the whole shot, so I get 15. Now, the problem with that is that you don't get the COLA increases because you're putting a set amount there. But you also avoid the VA compensation issue, which we're going to get into in a second. But because there's ways of getting around the VA issue, I would recommend doing the percentage route. Okay. Now, you can only receive your retirement for the spouse directly from DFAS, which is the Defense Finance and Accounting Service, if you meet the 10-10-10 rule. That's 10 years of service that overlap with 10 years of marriage. If you don't meet that rule, you're still entitled to get the retirement, but it has to be from the service member. DFAS won't pay you directly. Okay, now we're going to get into some more fun. This is where the litigation starts a little bit. Okay, so service members that are sufficiently disabled can be put, if they're not able to perform their duties, can be placed on military disability list, which means they're not going to be in active service, and they receive a pension. Now, they're going to get the higher of what their base pay was for how many years of service times 2.5%, or their base pay times their disability rating, which they have to apply for that. So they're going to, when they apply, they're going to be given a rating based on how disabled they are. So it can be 10%, it could be 100%. It all depends on their injuries. The problem with this is the amount that's attributable to the disability is exempt from being distributed to the former spouse. All right, so let's use an example. Now, let's say Colonel Jessup. He has a base pay of $9,000, and he's been in the service for 24 years. His rating is 40%. The first calculation is going to get you $5,400 per month. The second would get you $3,600. So, it's good for Colonel Jessup, not so good for the missus. He would get $5,400, but the first 36 is going to be exempt from being distributed because that's what is attributable to his disability. Does everyone see how that works? Okay. So, Mrs. Jessup gets screwed. She's only going to end up with $900 out of that 54, rather than 27 if that was all retired pay. Okay, so this is an extremely important case. This is what kind of sets off all the disability rules and how the former spouse will get screwed if your agreement is not done correctly. Okay, so Mansell is a case where about 25 years ago, a California Supreme Court awarded former spouse approximately 50% of the service member's retired pay. That included the amount of retired pay he had to waive in order to get his disability benefits. And the U.S. Supreme Court held that couldn't do that, that his disability benefits were his own property. They were not subject to being distributed in a divorce. So I think now would be a good time to just explain a little bit more about VA benefits. Now, if you can apply for a VA compensation based on any disabilities that you received in your service, whether combat-related or not combat-related, but if you don't meet certain requirements, you don't meet certain program eligibility, you have to waive dollar for dollar the amount of retired pay that you would have received. And these benefits are tax-free. Retired pay is not. So if you're eligible, you're going to apply for this. And so what this case held is the amount that you waive in order to get those VA benefits is not marital property, cannot be distributed.
Does it make any difference when the disability occurred, even if it was during the marriage and they were married subsequent to the disability?
It does in some respects, but basically whatever your status is when you divorce is when everything is based off of. So if you get disabled during the marriage, it's kind of a non-issue because you have no argument to get that anyway. If you get divorced or if you get disabled after the marriage, we're going to talk a little bit later about how you can recoup that for the former spouse. Oops. If anybody wants the site, it's, I messed it up, 490 US 581. Okay. So yes, VA compensation is where all the litigation is coming from. It's litigated a lot. I probably get phone calls 2 or 3 times a week from someone across the country that got screwed out of their retirement benefits because their spouse elected for VA benefits. Okay. Now, VA compensation is based on service-related disability. So, you get deployed, you end up getting brain damage, or let's say, just any experience in the service that relates to disability, and you're not discharged under dishonorable conditions, so that can be a general discharge, an honorable discharge, other than honorable, anything but dishonorable, you can get VA benefits. If you get dishonorable, you're screwed. Tax-free, so if you're eligible, you're gonna ask for it because tax-free, and you get to screw your spouse at the same time. It's a 2-for-1. What person going through a divorce doesn't want to screw their spouse? Well, you know what I mean. Okay. So you must waive dollar for dollar your share of retired pay unless you're eligible for one of the 2 programs I'm about to get into. So let's say you have your retired pay is going to be $3,000. You apply for VA benefits, and you receive $1,000 in VA benefits. So you have to waive dollar for dollar that amount of retired pay. So you only get $2,000, which is taxable retired pay, and $1,000, which is tax-free in disability. So it's the same amount, but your spouse will only get half of that $2,000 instead of half of that $3,000. So that's how you screw them, unless you have an credit agreement. Okay. That's for the election on the former spouse. Like I said, you have to make a dollar-for-dollar waiver of the retired pay. And the federal law says that only disposable retired pay is distributable, and that excludes the amount that you waive to get the VA. So this automatically will decrease the former spouse's share, and they won't even know about it. All of a sudden, look at Kathy going along, you're receiving your $2,000 a month from DFAS from your ex's retirement. All of a sudden, you get $500 a month, because he made an election. A lot of times people don't realize this till 15 years down the road, so they've lost possibly $100,000, who knows. Okay. Okay. Title 38 U.S. Code 5301 says that VA compensation cannot be attached. So you can't seize it to satisfy a debt. Now, but the general rule is that VA compensation is income for the purposes of determining child support and spousal support. Case of Rose v. Rose held that the U.S. Supreme Court held the father could be in contempt for failure to pay child support, even though VA was his only source of income. Now, child support, slam dunk, is always going to be income. Spousal support is still being litigated a little bit. In New York, right now there hasn't been a whole lot of appellate division decisions about this, but there have been a few trial court. One was in Supreme Court. It said that it's not income for spousal support. One was in family court, said it is income for spousal support. So go to Supreme Court if you don't want it to be income, file a spousal support petition in family court if you do, or someone appeal it. Then we'll have some real law to work with. All right. This is programs I was talking about, which back in 2004, the Army realized what a big problem this was. So they started passing some programs that will help get rid of the waiver requirements. So if you have a 50% or higher service-related disability rating, you've been in the Army for, or military, wherever, for 20 years, you can qualify for concurrent retirement disability pay. That means you get your retired pay, but you also get this disability pay without having to waive any of your retired pay to get it. It's good for both parties because the service member is going to get this extra money each month, and the former spouse won't lose any. So the service member is still going to get an extra check, but at least you're not going to detriment the former spouse any. This is also going to be taxable. There's also an extra payment for combat-related special compensation. Now, you only have to have a 10% rating for this, but it has to be related to combat. This is tax-free, and you have to have 20 years of service or be medically retired. Let's go back to our friend, Colonel Jessup. Okay, so Mrs. Jessup was awarded 50% of Colonel Jessup's disposable retired pay in their divorce. Everything's fine. 6 months go by. All of a sudden, Colonel Jessup applies for VA compensation. He receives a 40% rating, which gives him $500 a month in VA compensation, requiring him to waive the $500 retired pay. And that's because he didn't qualify for either program. He has a 40% rating, so he's out for the CRDP, and then it's not related to combat, so he can't get CRSD. And so he sees a chance to get some tax-free income, and he can also screw Mrs. Jessup at the same time. Okay, so originally, upon retirement, they each got $2,700 of his $5,400, let's say. He applies for VA, he gets VA. All of a sudden, he gets $2,950, and she gets $2,450. This doesn't really seem that fair. So what do courts do? Now, New York typically uses an implied indemnity clause. So, for example, there's a case called Sideline v. Sideline, which I don't think is in your materials, but I have the site here somewhere. Might be on a different slide. Okay. And basically, the service after the divorce, the wife was awarded, and I use these terms interchangeably. It can be the husband as well, but typically it is the wife, at least currently. The wife was awarded a certain amount of retirement benefits in her divorce. About 5 years after the divorce, the husband applies for VA benefits. All of a sudden, the wife is not getting the same amount of benefits. So what does she do? She files a motion for contempt of Supreme Court. The court says, hold up, this is not fair. The husband's unilateral actions have made the wife lose what she was awarded in the divorce, what she bargained for. She's basically lost everything. So we're not going to let him do that. We're going to say, no, you have to reimburse her, we're holding you in contempt, and you're going to pay her attorney fees. So the wife, or the husband, doesn't totally get screwed, but we like to avoid litigation. So we can put some clauses in our agreements. Some other states do it a little differently. Over in the Midwest, they tend to just basically use the VA election as a change of circumstances to get the former spouse to get spousal support or more spousal support. It benefits the service member because now they're replacing a taxable benefit with a tax-free benefit, and then they get the tax deduction on the spousal support. So we're happy with that. And it doesn't really have effect on the spouse because both spousal support and retired pay are taxable. The other way some courts further out west do it are they just reopen the whole divorce. They say, all right, yeah. Game's over. Let's see what we can do. All right, you got the house. Let's give her 50 grand, 100 grand. Let's value what she would have gotten. So they're not totally screwed, but it creates for a lot of litigation. So let's plan for that. In our agreements, because 95% of divorces do settle, I always include an indemnification clause. So if subsequent to the divorce, you make a VA election or a military disability retirement election or any election that's going to decrease the percentage of what the former spouse is getting, you must reimburse her dollar for dollar for that. If you do not, and she has to file a contempt motion, you're paying for her attorney's fees. There's our Stibler case, if anybody wants to cite. It's 800 New York State 2nd, 357. Let me see this quick. And another consideration is also survivor's benefits. Basically, it's 6.5% of the retired pay. And what it basically does is it's an election you always want your service member to make, because if the service member dies, you don't want the wife to get screwed. Well, maybe you do, but if you have the wife, you don't. And it will come right off the member's pay unless it's the military division order says otherwise. So what I usually say, if I have the husband or the service member, I'm going to want the wife to pay for that. So maybe instead of 40% of his retired pay, she'll get 33.5%. It's because it's really for her benefit, so why should the service member pay for it? At the least, they should be splitting it, but he should not be paying for it. Okay. I think we finished kind of quick. But basically, what happened was the Supreme Court knew this was going to result in an unfair amount or unfair result by saying that former spouses were not entitled to any disability benefits because the service members are always going to make this election. Like I said, it's tax-free, and most of the time when you're going through a divorce, you don't like each other so much. So if you can screw each other at the same time, you will. But they said under the previous law that they were forced to do that result. And they trust the states to kind of come up with some type of plan. And for the most part, they have. It just creates some more litigation. So if you can avoid that litigation, I always think it's better. So make sure your agreements are airtight as possible. You want to address the VA compensation and the military disability retirement issues. Does anybody have any questions so far?
I have a question based on the handout.
Yeah.
Planning for disability pay. There's a section in the second paragraph where you're talking about negotiating a separation agreement or a property settlement agreement. In the next paragraph, you say that it would be enforceable under Virginia law. What about in New York?
It's enforceable in New York. That was just one case that we pulled out. And actually, I do have, I think off the top of my head, I have seen several cases where it just basically says whatever you agree to, we'll enforce it. But a court, without an agreement, can order you to split these retirement accounts. But if you agree to something, I mean, you can agree to whatever you want as long as you're not getting public policy, right? So it's enforceable in New York, too.
Okay, so this is an area that Congress said, states go ahead and resolve it.
Right. The Congress put certain rules in place, like the waiver of the retirement pay, states cannot divide that. But they also are letting states do what they want to some extent. Like the indemnification. That was not, Congress did not mention that at all. But Congress realized it's not fair for so a lot of the time, you know, people have been married for 30 years and the spouse is home taking care of the kids and contribute to the service member being allowed to go away for so long and get deployed. And so that, you know, they are entitled to some benefit from that.
Thank you.
Sure. Anybody else have any other questions?
How frequently do you encounter potential litigation based on these changes in the election, like
Yeah.
when they choose a disability?
I want to say probably about 20% of my military divorces. And it typically will become an issue at some point or another. It might not be an issue at this moment because maybe people are 45 and they're not retired yet. But, you know, once they do, I would say a good 70 to 80% of military qualify for some type of VA benefit, and if they're not eligible for those programs, they're going to have to waive, and then the spouse is going to lose out. Exactly. And so there has been a lot of litigation on it, and I think there's going to be a lot more. Anybody else have any other questions? Okay, we can talk a little bit, some other considerations. I don't know how much time we have. Another benefit that you can use to negotiate your settlement agreements is TRICARE. TRICARE is a very big deal, particularly with this cost of rise in health insurance. Now, if you were married for 20 years, the service member served for 20 years, and 20 years overlaps, that's called the 20-20-20 rule, then you can get TRICARE for life. If you are married for 20 years, served for 20 years, and there's 15 years of overlap, then you can get it for 1 year. Now, yeah, it's not, I mean, it's better than regular divorces where you get screwed, you know, once the papers are signed, you're done. But, you know, you can use it to negotiate perhaps a lower percentage of retirement benefits, or maybe a lower percentage of spousal support, or what have you, and just do a separation agreement for some period of time so that you can meet that 20-20 rule. And then the spouse can still can get benefits for life. And your kids can stay on it regardless, obviously. And it's free. There's no cost to the service member for the health insurance. Sometimes you do have to travel a little bit, you know, maybe half an hour away to find a provider, but it's excellent insurance. So that is a lot of a benefit that a lot of former spouses look for. Yes.
What happens when the retired military veteran has more than one former spouse?
Okay, so for survivor benefits, only one spouse can get it. So if your first spouse took it, then in the divorce I would negotiate a life insurance policy. And sometimes you may even want to look at getting a life insurance policy regardless, because it is 6.5% of your pay. So if you're getting $5,000 a month, that can potentially, I'll have a calculator in front of me. It's a lot of money. Just look at that. So a life insurance policy may be cheaper. It kind of depends on your physical condition. If you have a 9% VA rating, it's probably not going to be cheaper. If you're 75 years old, it's probably not going to be cheaper. But it really all depends on the circumstances. But yeah, only one spouse can get it at a time. Any other questions? Does anybody have any questions about how the benefits are calculated or divided? All right. I'm going to read the course number. It's SKL 1079. SKL 1079. So the main point is obviously just to make sure your agreements are very tight, and if this is going to be litigated, obviously you want to bring up all these issues to the judge with memos of law, or however it needs to be done. It's also often an issue post-judgment when we're fighting over quadros. A lot of times the service member doesn't want to put any of this information in and say, well, I'm not gonna file for VA, don't worry about it. No, you don't want to take that risk. You don't want to be fighting 20 years down the road, because once the service member starts receiving the retired pay, defense is not going back. So you're not going to get that. Trying to get philosopher's stone, yeah, you may be able to get it back from him, but realistically, money spent is money gone. So, you want to make sure everything is addressed, either with the court if it's going to be litigated or in your agreement, and so that it says that if he makes any election which decreases what you would have received but for that election, that he has to reimburse you dollar for dollar, whether it's because of VA or military disability retirement, whatever the case may be. You want to make sure everything is airtight.